Welcome to NC Elements of Crime. Our channel is dedicated to explaining North Carolina criminal laws in a clear, simple, and easy-to-understand way. Today, we're breaking down the elements of the crime of stalking in North Carolina. The N.C.G.S. General Statute is 14-277.3a. This video is for educational purposes only. We are not attorneys, and this information should be used as a general guide, not legal advice. At its core, North Carolina stalking law is designed to address repeated behavior directed at a specific person that goes beyond annoyance and rises to the level of causing fear for safety or serious emotional distress. This law focuses on patterns of conduct, not necessarily isolated incidents. Stalking is not defined by one single act. To prove this offense, the state must establish specific legal elements, and every element must be met. A person is guilty of stalking only if the required following elements are proven beyond a reasonable doubt. A person is guilty of the offense of stalking if they, willfully and without legal purpose, harass another person on more than one occasion, or engage in a course of conduct directed at a specific person when the offender, knows or should know that a harassment or course of conduct would cause a reasonable person to fear for the safety of him or herself, his or her immediate family, or his or her close personal associates, or suffer substantial emotional distress by placing that person in fear of death, bodily injury, or continued harassment. First, the defendant acted willfully. This means the conduct was intentional and done on purpose, not accidental. Second, the conduct was done without legal purpose. Third, the defendant must have committed one of two types of conduct: either harass another person on more than one occasion, or engage in a course of conduct directed at a specific person. Under this element, harassment must occur more than once. A single incident alone is generally not enough to meet this requirement. A course of conduct means repeated behavior directed at a specific person, rather than general or unfocused actions. Fourth, the defendant knew or should have known that the harassment or course of conduct would have a certain effect on a reasonable person. That effect may be that a reasonable person would fear for the safety of themselves, their immediate family, or their close personal associates. The conduct would cause a reasonable person to suffer substantial emotional distress by placing that person in fear of death, bodily injury, or continued harassment. Under the statute, harassment means knowing conduct directed at a person with no legitimate purpose that torments, terrorizes, or terrifies. A course of conduct means two or more acts, direct or indirect, such as following, monitoring, surveilling, threatening, communicating, or interfering with a person's property. Substantial emotional distress means significant mental suffering, and it does not require medical treatment or counseling. If a person is convicted of stalking and receives community punishment, North Carolina law requires a court to impose supervised probation in addition to any other sentence. North Carolina may prosecute stalking if any part of the conduct or the effect on the victim occurs within the state, even if other parts happen elsewhere. Stalking is generally charged as a Class A1 misdemeanor. If the defendant has a prior stalking conviction, the offense is elevated to a Class F felony. If a court order is already in effect prohibiting the conduct and the defendant stalks anyway, the offense becomes a Class H felony. To recap, stalking requires willful conduct without legal purpose involving harassment or course of conduct where the defendant knows or should know it would cause fear or substantial emotional distress. This has been NC Elements of Crime. Subscribe for more plain English breakdowns of North Carolina criminal laws.